I'm Nikki Jovicic from LookUpStrata, and I'm also Managing Director of Tower Body Corporate, a body corporate management company on the Gold Coast. For today's session, we're very happy to welcome Todd Garsden from Mahoneys. Todd is joining us today to talk about the big topics in Queensland body corporate for 2023. What's happening? What do you need to know? How are things changing? What effects will these changes have on the rest of 2023? We'll be specifically concentrating on the three big ones: the suspected management rights changes, insurance claim delays, and defects and water damage. Todd's presentation will be followed by our regular discussion and Q&As. Before we begin, I'd like to mention that the information contained in the session, including the discussions that arise from submitted questions and also the chat conversations that happen, are not legal advice and should not be relied upon as legal advice, and you should seek independent advice before acting on the information contained in the session. We're very happy to have Todd Garsden from Mahoneys back with us again today. Todd is an experienced property lawyer who specialises in body corporate law. Todd predominantly acts for body corporate managers and lot owners on all matters affecting bodies corporate. Todd is an active member of the Strata Community Association Queensland. In 2019, he was appointed to the SCA Legislation Committee and assists in making submissions on behalf of the SCA on issues such as legislative reform in body corporate law, and more recently, Todd was appointed to the SCA Membership Committee. As Todd is also a body corporate committee member, he understands the day-to-day requirements of administrating a body corporate. Todd has a focus on achieving practical and commercial results for his clients, and he understands the market in which bodies corporate operate. Todd also provides presentations and training on matters affecting body corporate industry to body corporate managers and other industry stakeholders. He regularly assists our Queensland readers with answers to their tricky body corporate questions, and you will find his responses in most issues of our newsletter and monthly editions of the Queensland Strata magazine. So thanks for joining us again today, Todd, and we really thank you for the support and continued help that you and Mahoneys provide to us.
Well, thanks for the intro, Nikki. Very nice, as usual. So I think when we started talking about this idea, we're trying to look about a topic for the webinar, and there was so much discussion at the end of 2022 about a number of different issues, and they really carried over to the beginning of 2023. So this is my view of what's going to happen this year. The three big things: could be wrong, could be right, could be somewhere in the middle, but I guess we'll have 10 months left to find out. So the three ones that I think are important is going to be the management rights changes, which is based on the questions that have been submitted already, probably the most topical one. So we might spend a bit of time fleshing out that in detail. Insurance claim delays, which almost 12 months to the day was a trigger of probably the most insurance claims Brisbane's ever been subject to, and most of southeast Queensland. And then, as it has been a big issue for a number of years now, defects, and most commonly water damage, which is obviously quite linked to those insurance claims from 12 months ago. So lots to get through. So we'll try and make sure there's enough time at the end for questions as well. So management rights. I'd say this is, of all the issues, probably the most uncertain, the most discussed about, and everyone's got lots of different ideas. So the issue, I suppose, is that there's lots of discussions and lots of noise about changing the term limitations for management rights in Queensland. So if you're not familiar with management rights, it's the traditional caretaking structure for a building. There's normally two agreements entered into. One's a caretaking agreement where the party looks after the common property, and the other is a letting agreement where they're given authorisation to act as a real estate agent and let out lots. So the background to it is that there's a maximum term on how long those agreements with the body corporate can run for. So the discussion is around changing what those terms are. So currently, under 90% of the modules are going to be standard accommodation or commercial, and those with management rights, it's probably going to make up 99% of them. So the current rules is that you've got a 10-year cap under the standard module and a 25-year cap under the accommodation or commercial module. That's what the current situation is, and there's nothing at the moment that has changed it. However, there's a lot of rumours and a lot of discussion, a lot of noise that the government is considering changing those caps. The reality is any change is most likely going to be down. So when everyone's talking about changes, even though no one knows what those changes are going to be, no one's discussed making them longer. All the discussion is about limiting them or making them smaller or changing them in some way, probably against what the manager's current interests are. So the impact is typically accepted that it's probably going to be bad for management rights. Obviously, a lower term of an agreement, whether it's 10 years or 25 years, is not necessarily a benefit to the manager. It's probably a bad thing for them. What has it had practically, even though there's been no changes yet? It's probably just slowed things down a bit. So I think everyone's taking a wait and see approach. No one knows if there are going to be changes, what those changes are going to be, if there are any. So I think everyone's just put the brakes on a little bit and trying to work out what's going on. I think there's probably been more talk about it than what's been necessary, and appreciate that this is probably adding fuel to that fire. But the reality is there hasn't really been anything put forward in concrete yet. So these proposed changes, assuming they're going to be some sort of limitation, there's lots who are ambivalent and don't really mind. I probably fall most into that category. Obviously, we've got a lot of body corporate clients, we've got a lot of manager clients. My view is until we actually know what we're talking about, there's probably not too much point getting caught up in the rumours and speculating about what it's going to be. There's obviously those who want to have the term reduced. So typically there are people against management rights in general. Some are pro-industry and just trying to find a fairer balance. I think that's probably the approach everyone should be working towards. A fairer balance is best for all managers as well, because it's a bit more protective for the industry. There's obviously a lot that might want it to stay the same. So primarily developers, they probably benefit the most from the initial management rights. Existing managers, they've bought into something on the basis of the current rules, pulling the rug out from under them. Obviously, that's not going to be a good thing for them. ARAMA's always going to support managers as they should. Banks, anything that affects potential value of the management rights, they're going to be against it. And obviously there's some associated industry professionals that could potentially be negatively impacted by these types of changes, agents, valuers, management rights firms, that type of thing. So as I mentioned before, no one's talking about making the term longer when we're talking about term changes. So it's probably a fair recognition that a 25-year agreement is a very long time. I don't think there'd be many managers that see out a 25-year agreement when they're given that term to start with. It's always assigned at some point. So I guess what everyone wants to know is what's going to happen. And the reality is this is the $1 million question. And I think people need to be prepared that it might be nothing. As we know, in the last 3 years ago, the regulation modules changed. And that only happened because the old modules expired and they used up all the extensions possible. So their hand was forced. Absent that, there's been very little, other than some COVID changes and some minor changes recently, very little changes to the body corporate legislation in the last 20 years. So the thing that you've always got to remember is who has sort of a lot of lobbying power with the government, and that's banks and developers. And if they're against these types of changes, obviously that's going to draw it back from what it possibly could be in some way. So changes might be something minor and might have very little impact. They might be something fundamentally huge that's going to really change the industry. Obviously, this is just speculation, but I suspect it's going to be something in the middle. I think if the focus is on finding a fair balance, it's very hard to argue for either side that that's the wrong option. So as I said, the next slide is purely speculation. It's just some ideas that I've come up with about what those changes might be of somewhere in the middle. So these are absolute guesses. They may pan out, they may be way off the mark. I really have no idea. So, the most simple solution would be to change that 25-year cap to a 10-year cap. the effect of that is there's going to be very little difference between the standard module and accommodation module, which is then going to raise a question about should there be a difference between the standard and accommodation modules, or should they just merge together? There are a number of other little minor administrative changes between the two, but it's all process driven. So I think if that were to happen, there'd be a pretty good argument that you don't need two different residential modules like that. So that's probably the most simplest option. Obviously, the middle ground is going to be somewhere between 10 and 25 years. So it could be a 15-year cap or a 20-year cap or any other number in between. They might change the threshold to increase the term, which is currently ordinary resolution, to a special resolution or majority resolution, so that when a manager comes for a top-up down the track, they might not just need more than half of the votes. They might need to convince a little more owners that this is what the building needs. So that's one idea. Another idea, which obviously can start getting a little more complicated, is that everyone starts with 10 years, so that the default isn't going to be 25 for accommodation modules, but you're allowed to go up to 25 if the owners really want it. So you could start with 10 and then after a couple of years, knock it up to 15, 20, 25 or something like that. I think no matter which model is chosen, it could be one of those four, it could be any other one, that 0.5 there is really, I think, quite important, which is a grandfathering provision. And what that means is that all the managers that have bought into management rights prior to a certain date, they're going to need some sort of protection, because I think taking away the value or the equity in that business overnight from legislative change, it's not, well, one, it's not fair, but two, it's probably a bad thing for the industry, because there's not going to be much confidence. And I think in an industry like this, you want confidence in the management rights model, not just for the manager, but also for the body corporate. Because if that can be taken away overnight, managers might be running for the hills. You might not be left with good quality managers, and there's a lot of good quality managers out there. And it's not going to be an industry people are going to be wanting to be involved in. So I think protecting existing managers has to be quite a high priority, no matter which model is chosen. So I'd be very surprised if there wasn't some sort of grandfathering provision that sort of set a date where agreements before this date have some level of protection, and then new agreements might have a different set of rules. So my sort of thoughts, a little bit of a rant, I suppose, but the issue for me isn't necessarily about term. I don't think a manager who has a 25-year agreement and a manager who has a 15-year agreement is going to give the body corporate any better control over that manager's performance. The reality is, if a manager is doing a great job, the term of the agreement doesn't matter if it's 3 years, 5 years, 10 years, 20 years, 25 years, the building's happy. I think the issue more so, not necessarily around term, the issue is around performance management. So the problem really is with the industry is when you have a poorly performing manager, there's some mechanisms you can use, but those mechanisms are quite slow, drawn out, and very technical. So I think a bit more of a focus should be around finding a better way to improve performance, as opposed to let's just decrease the term of the agreement. I think it's an indirect solution. Don't think it's the most effective solution. So I think there's some middle ground that needs to be found between maintaining the value of a business, which is good for the industry, and ensuring that the body corporate has the power, ability, and protections to make sure that the manager's doing the job. So whether that's bolstering the move-on provisions or the forced assignment provisions, or changing how management rights agreements are drafted to give the body corporate better protections, or performance measurements, remuneration changes, that type of thing. So I think there should be more of a discussion around that as opposed to just term, because I think term is trying to solve an issue, but I think it's trying to do it indirectly. So I suppose summing up for management rights, these sort of discussions around term have always been there. There's always been a discussion from some people that 25 years is too long, and to be fair, it's a very long time. I think the difference now is that the chances of a change happening are probably the highest it's been before. there's never been this much discussion or indication from the government that they will be looking at this issue. So if they're going to do it, it's probably going to be now. I don't particularly suggest jumping at shadows or speculating about what things could be. So I think it's going to be very interesting to see what's proposed, when it's proposed, how developers and banks are going to react. Because as I mentioned before, they're going to have a lot of influence on ultimately the end decision. So one way or the other, it's going to be quite significant because it hasn't really been changed. So this is the first time it's really been looked at and potentially going to be changed. So I know this is probably going to cause a lot of discussion in the chat later, and we've already got a lot of questions on it. So I think we can get into the nitty-gritty of that in the question time. So separate issue that I think is going to be a big thing for the remainder of this year and was a real theme for the majority of last year is insurance claims and insurance generally. So if we all remember 12 months ago, the floods then flooded insurers with claims. I think the amount of rain that happened in the area would have found every single crack and leak in any property in Brisbane. It was really a water test. There's so many insurance claims that were made in February and March last year that are still not finalised. That delay has just added to those damages, because if you've had a unit that hasn't been able to be rented for 12 months, not only is the damage to the unit need to be repaired, the damage gets worse if it's water. Obviously, mold grows. It costs more, and you can't rent that out, or you need to live somewhere else. So every month or every week that this claims aren't finalised, it costs the insurers more and more. The cost to insurers, I think, has been extremely significant and underprepared, and it's just being exacerbated by the fact that so many trades are in short supply at the moment. So even if the insurer wanted to fix everything tomorrow, they just simply can't. So they're in a really tough spot where they're trying to prioritise which works get fixed when, and trying to manage the cost of all that, so they're not paying 2-3 times as much as they should be to get it back up and running. So as much as a lot of this is complaining about the delays, and quite right, you've also got to remember it's been pretty tough on the insurers trying to organise all this and fund all this. So it's a bit of a balancing act. So we've got a number of matters in the last couple of months that would typically have been a claim we would expect to fly through in the normal course. But insurers are really looking at their policy wording and really trying to push back on a lot of claims that kind of fall in the grey area, or even trying to push the limits a little bit more. So I think insurers by almost necessity have had to go back, review their policy wording, and really work out whether or not a claim that's been made properly falls within it. And if there's the ability to disclaim or exclude an insurance claim, then they're almost forced to take it. So I think that's been a really somewhat unfortunate but consequential issue from the situation. So obviously that leads to a lot of disputes. So there's a dispute with the insurer about did you properly disclaim? Should you have approved this claim? Delays about making decisions around that. And those disputes can take a while, and there's industry bodies that can resolve them, but they're not fun disputes, because the reality is if the insurer has properly disclaimed, there's a whole bunch of damage that the lot owner or body corporate's then responsible for. So the second layer of dispute that directly leads to is that you've now got an argument between the owner and the body corporate about who's responsible for the work. And sometimes it can be quite difficult, because if you've got a water leak that's caused or flooded a unit, identifying why the water got inside can be quite difficult, because it could be a genuine defect that the body corporate was responsible for. But at the same time, body corporate can't prevent a flood, and they're not obliged to prevent a flood. So working out who's responsible for what damage and why it was caused is a really big source of contention at the moment. So if we talking about insurance claims, we just put them aside for a moment. I think something that bodies corporate owners need to remember is that whether or not insurance will cover the damage or won't cover the damage, there's still statutory maintenance obligations between the body corporate and the owner. And whether or not you have the ability to recover some benefit from the insurer, it does not change those obligations. So if your common property is damaged and you have a genuine claim with the insurer, you're still obliged to get that common property fixed. So whether or not that's working with the insurer for a cash settlement so that you're able to go and fix it without losing those rights, the body corporate can't just take the view that, well, we've made an insurance claim, there's nothing we can do until the insurer deals with it. They've still got a statutory obligation to make sure that it's fixed. And if the insurer is taking a bit too long, then I think there's a bit more proactiveness needed so that the body corporate can go and find its own trades and fix the problem. Obviously, that is a bit of an unfair chip on the body corporate. As I just mentioned, it's very hard to get trades and competitive quotes, but that statutory obligation isn't excluded because it's hard to do it. They've still got that obligation. So I think that's what this next year is going to bring about. I think people were relatively understanding over the last 12 months that, yep, there's a process, it's going to take time. But I think we're at that tipping point now where it's been 12 months and they want to see something being fixed. So there's a lot of disputes that we're involved in, and I'm sure there's plenty more where owners are going to the body corporate. They've asked for the repairs to be done. Body corporates hasn't been able to or hasn't done it, and they're going to the Commissioner's office to get an order forcing the body corporate to do it. And I think that the large majority of those applications are going to be successful because the adjudicator can't say to the owner, well, yes, they've got a statutory obligation to maintain the common property, but they're waiting for an insurance claim because that exception doesn't exist in the legislation. It's an absolute responsibility. As I said, it puts everyone in a tough spot. It's going to be even tougher for the body corporate to defend if they've made an insurance or they've delayed repairing the work because they've made an insurance claim, and then all of a sudden they find out that they're not even covered for the claim. So in that situation, the body corporate really needs to get organised and get those works carried out and work out whether or not that insurer has properly disclaimed those works, because there are sources of redress if that's the case. But the reality is you've got that overarching statutory obligation to fix common property. If there are still defects, the responsibility of the builder, and this ties in with the defects discussion later on, you still need to fix the work. I think that's the paramount takeaway from this section of the discussion today, is that the body corporate is obliged to fix things. And when it is, it can't say, well, we're waiting on the builder or we're waiting on the insurer. They've got to take those positive steps. Just spoken about a lot of problems, but not many solutions. So if you're an owner, I think what you need to be doing is getting onto it as early as possible. Progress those issues sooner rather than later. Get your application in before the next owner does, because the reality is the faster you progress it, the faster you're going to get an outcome. I think with things banking up in the Commissioner's office just because they've just been inundated, similar to insurers, if you wait longer, if you wait a week, it might not necessarily add a week, it's probably going to add a month to the solution. So I think getting in there early, if you're still not seeing progress, I think you need to start working out if you're responsible or the body corporate's responsible, and if the body corporate's responsible, putting that on them. If you're the body corporate, I think making sure that you are strictly making sure that the insurer is following the policy. If you're entitled to coverage, you've got to keep on them. As with most things, the person who shouts the loudest gets the most attention. So insurers are going to have to prioritise and triage to some degree. If you're pressing harder, you're probably going to get a little bit more attention than the building next door. So I think make sure you understand your insurance position first. And if you're not covered under insurance, you need to get the works done. Not the best solutions, but that's probably all we've got at the moment as a consequence of the water, which really sort of leads to this final topic. And it's a topic that, as I said, it isn't necessarily new for 2023, been around for a number of years, helpfully highlighted by the new regulation modules a few years ago that sort of I think the most significant changes were in relation to defects. Defects are a reality. They need to be expected. It's just the issue is, as I've highlighted, bolded and underlined, early action. So there are almost always rights that someone was entitled to rely on. The problem we see 9 times out of 10 is that they were too slow to use those rights. So there are good, strong rights in relation to defects. The problem is actually using them with enough time. So we have clients that come to us with an almost perfect claim against the builder for defects. Problem is they're too late. Either the builder went under a month ago, which is one that we had, or you've run out of time to make a QBCC application or sue the builder. So if they came to us a little bit earlier, they probably would have been fine and they probably would have got a result, which I think is more frustrating than coming to us with a bad claim. So I think it's important to understand what a building defect is. There's heaps and heaps of definitions. That's what we put as the sort of generally accepted definition that QBCC will typically work from. The reality is every contract is going to have probably a different definition of what is a defect and what rights exist. So it's not a one size fits all. A defect can be a defect for one building, but not for another, depending on what the contract says is a defect. The one key takeaway here, I think, in this section is about the importance of that construction contract. So this is a fairly misunderstood issue because it's the body corporate who obviously we're expecting and we want to take rights, enforce rights against the builder. So there's a construction contract somewhere. Typically that's between the developer who owned the land before the body corporate was created and the builder. Body corporate's got nothing to do with that. Body corporate didn't even exist when that contract was entered into. The rights in relation to defects are founded in that contract. So the developer at the starting point is the party who can take action against the builder. However, what the BCCMA does is it takes those developers' rights, picks them up and plonks them with the body corporate. So that effectively the body corporate becomes a developer party under that contract and that the body corporate can take action under that contract. And that's in relation to the common property. Owners are given those same rights in relation to their lots. And then there's another mechanism that allows the body corporate to basically pick up that right from an owner and enforce it on their behalf. So I think this is a key takeaway that you're actually acting as the developer's rights when you're taking in defect action as a body corporate. You're pretending you're the developer. So there's a big misconception between the builder and the developer about who's responsible. And it's the builder who's responsible for defects and that you're using the developer's rights to enforce those defects. This next point is to clarify the developer's role. And their role is fairly limited. It's providing construction documents to the body corporate to enable them to take the developer's rights on. Getting a copy of those contracts is the starting point. So when we're starting to look at a defect file, first thing we try and find is a copy of the construction contract. So it's supposed to be handed over at the first general meeting. Doesn't always happen, but really should. There's a statutory obligation on that developer to hand over that construction contract, along with a number of other documents that help the body corporate. There's normally template motions that say it's been handed over, but whether it has or not isn't always the case. So the newish regulations from a few years ago didn't necessarily change the rule. They just really clarified it and expressly said that they need to hand over the contract for building work. I've probably harped on enough by now, but that contract is really important. And before we can really do too much, you need to get a copy of that contract. Once you've done that, there's probably typically 2 streams of action that the body corporate can take. One's complaining to the QBCC and one is enforcing that contract against the builder. So if we look at the QBCC, you lodge a complaint for defects. That'll typically lead to QBCC investigating. If they agree that there are defects that need to be fixed, they then have the power to give a direction to the builder to fix that defective building work. They don't take any further enforcement action from there. So if they give a direction to rectify and they don't rectify the defect, QBCC doesn't police it. So all that will really happen is they'll get a black mark on their license. That's not the biggest stick to use. It's not particularly scary. Builders sometimes have a different special purpose entity for every single construction contract. They might just put that entity down and start up a new one for the next one. So there are some cross linkages between common entities and nominees and directors, but it's not always the most effective route, and it can take a bit of a long time at the moment, because unfortunately, like the Commissioner's Office, QBCC is probably a little bit underfunded, a little bit overworked, and the timeframes that you need to get your applications in have become so narrow, because the deadlines are actually based on when the QBCC does something, as opposed to when you put your application in. So if they're running late on things, we can miss out on using some of those rights QBCC has. Quick overview of those timeframes is that you need to put your complaint in within 12 months of knowing about the defect. So that's a really key takeaway, because sometimes people think, oh, it's a major defect, we've got 6 years and 6 months, but you also need to make your application with 12 months of knowing. So as soon as you know about it, you've got to get into gear and get that application or that complaint to QBCC going. Other than that 12-month timeframe, that works from the beginning of when you find out. You've also got 2 other timeframes to be aware of that sort of work in the reverse. So when the work completes, you've got 12 months to make a complaint for minor defects, and 6 years and 6 months for major defects. And that's when there's, risk to injury, structural issues, or sort of water ingress. So timeframes is big takeaway from this. Common question a lot of time we get is, well, what about the warranty insurance scheme? Shouldn't QBCC just appoint a builder to fix the defects? And that only works if you have less than 3 stories. So your apartment complexes won't be covered by this. So can be very useful for some of your standard format plan developments. But again, there's some really strict timeframes, which I've sort of set out there. And you note that that's 3 months of noticing the defect. And the other one for non-structural is 7 months from the work being completed. So again, there's very little time to get organised to make these types of claims. So again, timeframes are the scariest and most technical issue, because you might have a perfect claim, but as soon as you go over that deadline, no one can extend it for you. You've lost that right. Probably the more substantial right that has a bit more teeth is enforcing that construction contract. So you're being the developer and you're enforcing the developer's rights under that contract. As any sort of typical legal matter will start with, there's some letters of demand that slowly ramp up, and then you eventually can end up in court. Strict timeframes, again, 6 years from practical completion is when you need to have that filed. There's no point filing something if the builder doesn't have any money left over, if they've gone bust or something like that. Again, you might have a perfect claim, but there's no point spending money chasing bad. When you get to this stage, detailed evidence about the defects is crucial. So having independent defect assessments by someone who knows what they're doing, has done them before, and can stand up in court is the most critical point at this point. So defect assessments, they're really detailed reports that set out all the condition of the common property. There's preliminary defect assessments, which help for letters of demand and QBCC applications, but there's different levels depending on how far we're pushing it. So obviously, one that goes to the court is going to be a lot more detailed and cost a lot more than one that we're submitting to the builder and asking them to come back and please fix the problems that you've created. So very important you use the right expert with the right experience that can produce the right amount of evidence to actually get your claim up. Helpfully, and I think this is one of the best changes of legislation from the new modules, is that the body corporate is obliged to consider getting a defect assessment report at their second AGM. That's to help with timeframes. That's to help with managing defects early. It's not an obligation to do the assessment. It's an obligation to consider doing a defect assessment. And I can't think of a single reason why someone would vote no to that. It almost is a protection for the builder if you're voting no to review the builder's work and then you want to complain about it a couple of years later. So that's a positive obligation to do it at the second AGM. There's nothing ever stopping a body corporate doing it at any other time, and I think they should. I don't think it's just, we'll do one at our second AGM, and if it turns out all good, then we don't have to worry about it. I think the obligations of a body corporate go a little bit further than that, whether it's expressed or not in the legislation, that they should be doing it more regularly, and particularly if they're aware or there's indications that there are defects. So just because you have to do it at the second AGM doesn't mean you can't do it another time. And finally, something I just wanted to cover off on defects is that the body corporate manager and the caretaker and the on-site manager is not responsible for defects. They're not responsible for fixing them. It's not in their agreements. But what they should have is a working understanding of the process and how things tie together. So I think it's important for strata managers and on-site managers to be aware of who are good defect assessors that can be used, who are the repairers that we trust to go in and fix the work that needs to be fixed, and what lawyers do we want to use to manage any defects or work out whether it's worth pursuing. So as Nikki alluded to earlier, we've got a guide that is hopefully a bit of a framework to at least get you started on some of those preliminary issues. That's my view of what's going to happen this year.
Wonderful. Thanks so much, Todd. That was really interesting. And obviously, there was a lot to get through with the 3 really big issues that we covered. I thought it was great that we could get a bit of an insight into what was happening out there. I think a lot of people in here wouldn't have the availability to the insights that you've given us. So thank you so much for that information. I found the very last section on defects really interesting when you were mentioning the body corporate rights to the responsibility of the defects and the way that runs through, and the role of the developer and the summary of the timeframes. I thought they were really great slides. And I think when I had a look through that report that we're sending out, you've got a bit of a flow chart in that you've developed with Sedgwick that assists as well.
Yeah, that's right. So I think the biggest question we've got, and just trying to get people on the right track is, well, where do we start? So with Sedgwick, we've got a bit of a process map, which really helps if you're a bit of a visual learner, which it helps crystallize exactly what I've just put in writing in a bit more of a diagram form. So I think that's something to look out for in that guide.
Excellent. Yeah, I'm sure that will be really helpful. So yeah, please have a look at that when you get the link to that later on today. Okay, we had lots and lots of questions. So the first one, with the possible changes to management rights, will there be a date set for new strata plans that prohibits management rights? I've brought an apartment off the plan, which currently has management rights within the contract. The project has been delayed by the developer and it's not expected to be built within the next 2 years. I'm hoping during this time legislation states there will be no management rights for buildings completed after a set date.
Yeah, I think that's extremely unlikely. Even the most significant changes that have been discussed or thought about haven't considered prohibiting management rights, particularly if it's granted by the developer. So if a developer's already disclosed this is the management rights we're going to be entered into, it's going to be very difficult for them to then be forced to change what the structure is because they effectively promised it to owners, and there's a lot of other legislation they've got to comply with in relation to when they disclose something, they need to follow through on it. They're probably not going to be prohibited.
Okay, thank you. Okay, we had another one also about management rights, and this one's stating, after talking to a few owners of other apartments here in Queensland, I've noticed a trend. It appears some astute caretakers and letting agents who only have the next 2 years secured are aware of the possible changes and the capping of management rights, and they're locking in new 10-year contracts now and exercising the right of the previously agreed extension. I know legislation hasn't confirmed any cap as yet. If this does go ahead, especially if it's early this year, can the body corporate call an EGM to reduce the contract to the possible new 3 or 5 year cap? And not everyone follows Strata news. Owners I'm speaking to are shocked to find they've not been made aware of the possible reduction in terms when asked to vote, and they're feeling they're being duped by the caretakers. So are lawyers doing more new contracts because of the looming caps at the moment, Todd?
Yeah, so I think managers under the standard module, which is when there's the existing 10-year cap, they've always topped up their agreement every 2 to 3 years. So I don't think that's a new issue where they're sort of changing or being aware of it. That's normally because their financiers require them to do that. So if they don't have their top up and they get below 7 years, they've got to pay extra interest. So I don't think that's necessarily a new thing. You can't sort of already set your own cap on management rights. So the legislation allows for a maximum term. The body corporate can't select a different limit or a lower limit. That's a no to that second part of the question. I think it's a bit unfair on managers to say that they're duping owners by putting up motions that they've always put up and probably are being required to be put up from their financiers. It's not their role to give advice to owners about potential legislative changes that may or may not happen. So if that were the case, that's all they'd ever be doing. So probably a bit unfair on the managers. And on that last point, I don't think there's probably been an increase in new agreements or things like that. I think if anything, it's probably been a little bit of a wait and see approach. So I think managers want to work out if there's going to be changes, and if so, what they are, before they start fiddling around with the new agreements. So I think at first there was a little bit of probably a slowdown, the opposite. But I think things are going somewhat back to normal until we actually know what changes are going to happen, if any.
Okay, so everyone's taking that wait and see approach at the moment. My scheme got hit this year with an increase in the water damage excess from 1,000 to 10,000 for each and every claim. Does this seem reasonable? If the 10,000 excess is defensible and presumably based on a poor history of claims for water damage, should the committee start factoring in extra payments for water damage repairs in our annual budgets? Our annual premium is around 56,000. Our major spending limit is 15,000, and our broker could not get anyone they deal with to lodge a second quote. Are there any alternatives out there?
So the increase in water damage excess, yes, that's probably going to be reasonable, particularly if the insurers had a lot of previous claims on that policy. They've probably already lost a lot of money on it. There's plenty of adjudicators, and we've, I think, had a couple of disputes in the last few months where, there's a high excess, and it's an unfortunately high excess, but that's the reality of it. And there's nothing really anyone can do too much about it. I don't think the body corporate should be budgeting for higher excesses, because typically if there's a water claim excess that's responsible because of something that happened in a lot, that excess can be passed on to the lot owner. So I'd be saying to the body corporate, you should probably be passing that excess on to the person responsible rather than budgeting to pay for it yourself. And that third question, if that's the best policy the insurer can get, then that's what you're stuck with. You can't not have insurance as an alternative.
Also, we have had a question, Todd, and it's to do with Airbnb. So that's something, of course, we haven't touched on today, but they're just asking, is the government reviewing Airbnb and external agents and provide more rights to Strata on this? If management rights are affected or reduced, this apartment management is likely to increase.
Yeah, I mean, I know years ago when the discussion papers were put out, short-term letting was one of the big things on there, along with smoking and pets. So I mean, is the government reviewing it? I suppose, but whether it's more or less than what they previously have, I think it's, and again, it's really difficult to guess what they're going to do, if anything. So I do know those discussions previously were to allow bodies corporate to have a way to stop it. So it's not going to be sort of loosening it. If anything, it's going to be tightening it.
Okay, thank you. And we had a few about defects come in. One of them was New South Wales seems to be moving forward in adopting new regulations to control defect issues. Can you summarise what some of these are and if you think they would be beneficial to Queensland?
Yeah, I mean, New South Wales has probably been a little bit more proactive with their defect legislation than Queensland, even though they did copy our legislation when they redrafted theirs. That's a bit of a state of origin jab. But I mean, they made developers a little bit more responsible for defects, which is what I just spoke about, was almost the opposite in Queensland, where the developer isn't responsible. I think there's powers where they can delay giving occupation certificates if there are defects, which forces the developer to fix them before basically handing it over to the body corporate. That's a bit of a practical ability there. I think there's a sort of developer rating system, so they can't sort of duck and weave and just use different entities all over the place. And there's a bit more of a sort of like rate my agent, but rate my developer process. They sort of created a duty of care for builders because there was, when I said there's a QBCC angle and there was a contract angle, there used to be an idea of a third angle about negligence, and that was sort of knocked on the head in a big decision in Victoria a couple of years ago. So I think they're trying to open that door so that that third angle can be introduced, so that there's actually duty of care. And if that duty of care is breached, there's a negligence claim against the builder. I think historically, even they probably even had a leg up in New South Wales because there was a bit more of a robust insurance protection for defects in New South Wales. So I know there was some practitioners down there that almost solely specialised in that type of litigation of enforcing insurance policies for defects. So that's from what I know exists in New South Wales, but it's very different to Queensland.
And I guess on the back of that question, that same person also asked, should Queensland have a building commissioner like David Chandler in New South Wales?
Sure. I mean, it's a great idea in theory, but of course, anything like that comes at a cost. So someone's got to pay for it. And I mean, if we just say let's pass it on to the developers or the builders, that will flow through to owners. Ideally, great. I mean, I think we're blessed in Queensland with the Commissioner's Office to deal with strata disputes. It's easy to complain about lots of little things, but the fact that it even exists is fantastic. So having something like that in Queensland might be great, or even just expanding the QBCC's powers a little bit more and giving them a bit more funding so they can really do what they're established to do would be great.
Okay, thanks, Todd. And we also had another one about insurance claims. With the premium prices rising and set to rise in the future, are the legislative rules around what elements must be insured too restrictive? Should this part of the legislation be reviewed and possibly amended to help allow more flexibility and affordable policy offers?
Yeah, I mean, my view is no. I mean, insurance is expensive. There's no doubt about it. But I think the cost of not having insurance far outweighs the cost of insurance. So I know there's a client a number of years ago that had a cyclone rip through it and almost totally destroyed it. And it, obviously very awful, but they were covered by insurance. So everything was fixed. And then they struggled to get a costly insurance cover. And they were looking at not getting insurance. And I just thought that was almost the most backwards reasoning, because they've just proven that you need it for that exact reason. So for you to know that it's a risk and to want to actively avoid being insured for that, even though it's going to be expensive, I think that was a little bit of a poor choice. Insurance is going to get more and more expensive. They've just lost a whole bunch of money over the last 12 months. Definitely an insurer would not have done well and will not do well for a little while. They're still licking their wounds from the flood. So you're paying for a very valuable service. Your building gets knocked down, someone will fix it for you or give you money to fix it. Yes, that's expensive, but I think you can almost never over-insure. So I probably wouldn't want to be trying to carve out issues in an insurance policy.
Are you finding in Queensland there are many buildings out there that are at risk of not being able to get insurance because of defects that they have?
Look, because of defects, yes. But when it's because of defects, they've got an obligation to fix it. So that shouldn't be the case. There's always someone willing to insure you for the right price, whether that's looking at international brokers or something. There's always an insurer out there. It just might not be the easiest or most effective option.
We did have a question just about cladding as well. So do you have an update on what's been happening? I think someone in your office has just written an article on cladding as well, and we'll push that out probably next week.
Yeah, just published it recently. A really good article that sort of talks about what's happening with cladding. So obviously there were those 3 stages. They all had those deadlines that people needed to comply with, and somewhat by surprise, the QBCC is going out and enforcing those deadlines. So there's complaints and summons being issued against Bodies Corporate and other owners of buildings around the traps, basically seeking fines because they haven't done what they were supposed to do. So I think the good thing is a lot of the really professional body corporate managers really actively managed it, knowing that this was a big risk, and they protected all their clients. And I think it shouldn't be underrated for those that have gone through that process and finished it, probably the value that body corporate manager provided in doing that. So yes, the QBCC is out there enforcing things.
And we might just do one more question. So management rights, would you purchase a lot in a building that had a caretaker with a long-term management rights contract in place?
I would, and I've done it. probably would do it again. Look, I think management rights is actually a very good model if you have the right manager, and thankfully I think we've got the right manager, so it just makes things a lot easier. But I do, as I see it almost every day, when there's a bad manager, it's a bad outcome. But I don't necessarily think that's the fundamental model. I think it's the lack of performance measures.
And like we always say at LookUpStrata, if you're looking at purchasing a unit, make sure you get a body corporate report done beforehand, and hopefully that will highlight any issues that are happening on the committee anyway, that might be around management rights as well. Do you think that would help, Todd?
Absolutely. And I think the biggest thing for that is owners need to read it. You can do all the searches you want in the world, but unless you're going to look at it or get some advice about understanding what it means, there's no point doing the search. Because I had 2 clients in the last 12 months that came to me not understanding what they bought into, and said, well, send me all the documents you got when you bought into it. And if they sat down and read the documents, they should have understood it. They just didn't look at it.
Fair enough. Okay, that's good advice as well. Thanks so much, Todd.
Okay.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.